So what are statutes? They're rules of conduct, of social conduct, that we guide our lives by. And it's important that they be clear so that we can guide our lives. You know, some of them are, you know, the golden rules that most anybody can figure out, no matter what culture you're in. You know, don't murder people. But there's a whole bunch of laws that we have on the books. I don't know how many volumes we are. 6 volumes is in the statutes now, 6 volumes of laws. And a lot of them are regulatory in areas that, good golly, if it wasn't a clearly written statute, we wouldn't know that what's legal and what's illegal. And that's what's really important, because how can we adjust our conduct to come within the law if we can't tell what the law is? So that's why we have statutes, to give us a code of social conduct. And unfortunately, they're not always clear. So for that first goodie bag, does anybody know why statutes aren't clear? No, you're all still asleep, right? Well, number one, because they're written in language, and language is imprecise. You know, what I write, isn't email a great example of that? What I write isn't necessarily what you read or understand when you read. You know, that's that, I'll go back to that cartoon, you know, I guess it's a dog and a person, but you know, or a cat and a person, you know, the little bubbles, what you're saying, come spot, sit spot, and you know, what spot hears is just blah, 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 blah. You know, and that's the same thing with statutes. You know, what's written doesn't necessarily come across with what you interpret when you read. So there's a writer's intent, there's a reader's intent, and all of that gets swayed by the facts that you know. Somebody might draft legislation based upon a certain set of facts. I always hate it when I hear a law that's named after some person. I hate that, because you know it's specific facts. And really, should we be legislating on specific facts? We can have a whole controversial conversation about that, but you know, like Jesse's law, or Ryan's law, you know, so written for, because there are some facts that the legislature thinks that, you know, we need some direction on. But then there's a whole bunch of situations that come up that your facts don't fit those facts. Well, that's another reason that legislation is imprecise, because it's written oftentimes with a specific set or specific sets of facts that are in mind, and how many facts can you think about when you're drafting it. And then, you know, the truth is always stranger. There's always these facts that crop up that just don't seem to fit. So that's another reason that statutes aren't particularly clear. And then the third really important reason, so the first one is it's language, the second one is facts can be not fit into it, and the third reason that statutes are sometimes imprecise is, darn it all, that drafter just really wasn't good at drafting. And that brings us to the fact that Linda thought it was really important to know, and I'm not sure, I thought we were a sophisticated group, but she didn't, she wondered, would we know that, sure, we got bill drafters in the legislature. Maybe y'all know somebody that's their job, bill drafting. And they read books like Bill Drafting, put together by the House or the Senate, Manual for Drafting Legislation. And so they have some training about how to draft bills so that they are clear. I mean, because the legislature's goal, the goal of any bill drafter, is to write a really clear statute so that those darn courts don't have to come in and interpret them. I mean, that's their goal. We want the law to be interpreted how we wrote it. So bill drafters have some training about that. But not all laws are written by our bill drafters. You know, sometimes, as Linda said, you know, lobbyists write legislation. Did we all know that? Lobbyists write legislation? No. So you're all shaking your heads, no. And so I guess Linda had that right on point, that lobbyists do write. So are they trained in bill drafting? Do they know the rules of statutory construction? are they so persuaded by the law that they want to have passed that sometimes they're looking at it with tunnel vision and not thinking about all those factual situations that might pop up that you're going to get, so that it would be considered vague or ambiguous. So there's several reasons why legislation isn't always as clear as it should be, and then we come to that's when we come to statutory construction and interpretation. If your statute is ambiguous, which means capable of more than one meaning, could mean two things, could mean three things, and once again, the facts may flesh that out, then the courts are going to be called upon to construe that statute. Or is it vague, incapable of any meaning? I think there's some statutes like that too. So, and that's when a controversy becomes a controversy in the trial court, and that's when it becomes it can become a controversy on appeal. As an appellate lawyer, I love a good case of statutory construction. Anybody know why? Oh, it's that standard of review, de novo. Any appellate lawyer wants a question, an issue that's going to be the de novo standard review. That means that means that appellate court's going to be able to decide it like a virgin, like the very first time. So that's really what I want. And, so a statutory construction issue in the appellate realm is a sexy issue. That's something that we all want. And, but I'm going to tell you, I want to be, y'all done any appeals? Where do you want to be as an appellate lawyer? You want to be at the lead, right? You want to be the person who's defending what the trial court did, because, I don't care what kind of an issue you have, the chance of winning on appeal it's a really uphill battle. I always think of myself as underdog, when people want to describe what I do. Well, I'm underdog. I'm the person who climbs that really big hill to make it turn out for my client when I'm an appellant. And I cite different kinds of, statistics, and, even the best of things. I think, the first DCA, 13%, some years it's as low as 8% of cases get overturned. 13%, depending on, hopefully if you've got that de novo issue, you can edge it up to 20%. But it really is an uphill battle. So that brings me to my best advice for any lawyer or any client about an appeal, winning at the trial level. That's your best chance of winning an appeal. So ideally, what you want to do is be able to tell you want to convince that trial judge that your interpretation of the statute is the correct one. And so that brings us to so how do you get to that point? Well, there's the rules of statutory construction. But I'm going to tell you this, no hard case is going to turn out because of the rules of statutory construction. Because in the end, we have to interpret a law so that it just makes good common sense. And you can pick, as I'll talk about in a few minutes, pick different kinds of rules of statutory construction to get your result. But in the end, if the judge is sitting there scratching his head, this really doesn't make much sense to interpret the law that way, you're not going to win. No matter how many rules of statutory construction you pulled out of your hat. So statutory construction comes into play, as I said, when you've got a vague or ambiguous statute that needs some sort of construction. And as I said earlier, legislators, bill drafters, that's what they want to avoid. They want that statute to be really clear. So, but when it's not, so there's some general principles. You're going to remember some of these from, do you remember law school? So, presumption in favor of constitutionality. We hear that a lot. as lawyers, the courts are supposed to interpret the law in favor of constitutionality. They're not supposed to just willy-nilly go, oh, that law is unconstitutional. And so that's kind of a rule that is always going to be in favor of your legislation. They're going to try to make us what sense they can out of it, and hold it to be constitutional. Because if that wasn't in effect, then where would be the strength of those rules that guide our conduct? If courts could just willy-nilly say, oh, unconstitutional, then we wouldn't have the security of the laws to be able to guide our conduct. And that's really what it's all about, having security in our rules of conduct. So then also you'll remember, construe the statute as a whole. Just look at that one little sentence and go, oh, there's the answer. You got to look at the whole statute and see, does that, there's the answer, make sense within the whole statute. And if it doesn't, then you're going to have to really engage in construction so that the whole statute makes sense. Okay, so then there's the rule about you're going to construe construction of a statute that defeats its purpose. That's not going to be favored. And I think we read that at about absurd results. So you should never construe a statute to come to an absurd result against the purpose of the statute. You know, you've got a statute that regulates something. You construe the statute so it doesn't regulate anything. Probably not against the purpose. So you're not going to construe it that way. This is a little dicey. Inferences should never be substituted for clear expressions. Now that kind of opens up a lot of wiggle room because, you know, you could say, and that's where that controversy about textualists comes into play. You know, what does a statute mean? And, you know, some people, if they go and dig up all that statutory history and what everybody said, they'll say, well, they really meant this. Well, if they really meant this, then they should have said it. You're not going to put an inference. You're not going to construe a statute with an inference. You're going to construe a statute when it's clear intent. So changes in the language are presumed to mean a change occurred. They meant a statute and they took off the word, you know, this is a prime example. I do some workers' compensation. We care a lot about attorney's fees and workers' compensation. And we had a case there that went to the Supreme Court on reasonableness of attorney's fees. It was written in the statute. You know, they have to, the insurance companies, when we win for claimants, have to pay us a reasonable attorney's fee. You know, remember all those Lee engineering factors, the ones that are in the Code of Professional Conduct about what's reasonable, they were all written into the statute, and they took it out. They left the word reasonable into the statute. So they had a case, Emma Murray went to the Supreme Court, and so there was discussion. What's a reasonable fee? Well, you know, what was paid to the attorneys in that case under the court order was, I can't remember. You know, I'm probably exaggerating at this point. $8 an hour, maybe it was $30 an hour. I don't know, some very small amount.
Closer to 8.
Pardon?
Closer to 8, I do call.
Yeah. So there you go. And so, hey, you answered a question. Yes. I'm going to give you a. Didn't even hurt.
Castle and Westfall are up right now, and they've already been heard.
Right. So we're waiting.
And we love you for that.
All right. Great.
And I'm hoping you're going to make me big money soon.
So the statute had the word reasonable in it, and the way that the Supreme Court decided that case said, even though those factors, those Lee engineering factors that used to be in the statute and had been removed by the amendment, that just brought them right back into it because the word reasonable was there, and under the Florida law, that's how you decide what a reasonable fee is, those Lee engineering factors that are codified in the rules of professional regulations. So that's what the Supreme Court did, read those rules into it. So you know what the legislature did? They decided Emma Murray in November, and next session in March, they amended the statute and took the word reasonable out. So that's the end of Lee engineering and the factors, maybe. There's a case there, as pointed out, Castellanos is another challenge to the same statute, which has to do with reasonable fees. How much was Castellanos attorneys paid?
It was 30 something.
Another, like $8,
Yeah, it was
you know, an
a
hour.
little bit more, but
Maybe a little bit more, maybe
ultimately workers' comp, if you were successful at the trial level, we used to get paid every hour we spent litigating an issue. And there's a reduced fee schedule in comp, so if a client's about to get an MRI and you were gonna pay cash, it'd be $2,000, but under the reduced fee schedule for comp, it's $600. So if I go to trial on that issue and I win, I get $60 for trying that entire case. And the employer's attorney that fights me on it can charge as much as they want to and will put me through the ringer, send every records custodian depot, and just waste my time. And so that's the issue with the constitutionality of the statute for comp.
That's right. So that's how it really affects you. It's the bucket.
I got a question. Where do you find the courts go to, you know, the first place we start to is the plain language of the statute.
Mm-hmm.
But on those occasions where, I guess this is subjective, my observed result may be different from my opposing counsel's observed result. And if I understand that if it's an observed result, they do look at the intent behind it? How does that work?
Let's get into that. Let's see. So if you've got a case that's going to have to be construed, let's talk about that big controversy about how we're gonna construe that. And I think you're all lawyers. You've heard about Justice Scalia. He is the biggest proponent of textualism, looking at the language of the statute, the structure, not looking any place else to find out what the intent is. And so. Well, I guess if statutory constructions just get together, this is really hot button stuff. I mean, this is what statutory construction people get excited about. Should you be looking someplace else? Now, I worked at the DCA for 15 years. Right across the street was the R.A. Gray building where the state library is, and that's where the state archives is kept, and that's where they had all those recordings, legislative committee meetings, minutes, papers. They had files on every law that was ever passed. And so, if you all scratched your head and looked at the statute, well, gee, what's the statute? I just walked across the archives and pulled up the information about it, and there it is. Staff analyses, minutes. You could go and listen to those legislators on the tapes. I don't know, I guess they're probably CDs now, right? But you could do that. But would Justice Scalia want me to do that? No. Those are not the words in the statute. And I guess we all talk about it as lawyers. You don't want to see how the sausage is made. I think they often say that about legislation, right? I think Bill will tell you that, right? You don't want to see that.
In the Senate of Florida, they used to, years ago in the old Capitol, they had glass top tables and glass tops on the desk, and underneath was a piece of paper about this big, and it said, "Laws like sausages should not be seen in the making."
Yeah, right. So, because it's, and I guess that's another reason why it goes back to why language is imprecise, is because, and we've heard this before, laws are made by committees. And so, you want a particular thing set in the statute, you don't. So, somehow, the two of you are going to get together and you're going to come up with some language so that you're happy and you're happy. Maybe no one else will be happy in the world, but you'll two be happy and you'll both be able to vote on it and pass it. So in terms of that, so the rules of construction, and then that's where the big controversy comes. And I think that that's kind of what brings us today to a new height in discussion on statutory construction. Oftentimes, you go and you just listen to what the rules of construction are, the canons of construction are. But I think that that's important. When I recently had an interview, I applied to be a district court of appeal judge. Anyhow, one of the questions that they asked me is, if any of you aspire to that, they said to me, "So what's your judicial theory?" Well, are you a textualist? Are you a contextualist? Is that a word? I don't know. It seems to be the opposite of textualist, contextualist. Those people that look at other things other than the statutes themselves. So what are you? Well, I think that I think somebody says it. We all say we're textualists. But where do we go after that? To really, are we textualists? I think we're all gonna stop and look at the plain meaning of a statute. Sure, we're gonna go and delve and look, we're gonna read the statute. Oh, when we're gonna interpret the statute, we're all gonna read the statute. But where do we go from there? And that's where those hard facts, make bad law, that's might send us over the street to the archives, to the RA Gray building to read the staff analyses. Really, what was the purpose of this? So does that make us anti-textualists if we read those staff analyses to help us understand what the plain language is? I don't know. Does it? What do you think, Kathleen?
I don't think so.
No. No. But somebody like Justice
Oh,
Scalia
heck yeah. Yeah.
would be slapping your hand.
But Scalia looks at the intent in any way whatsoever as to what they meant when they said that. When he goes back and talks about the textualists, with the original framers, he says, well, this is what was there, and he looks at the time there. So in some way, you go back and look at what was meant, even if you're a textualist.
And that's what I'm saying. How can you truly be just a straight textualist? Because, something that was written 200 years ago, how does that fit into our world today? Under the facts that we have now? There's all these laws now about things that are, y'all going to talk about internet stalking. Is that part of, with the human trafficking that's going on and cyber stalking and things like that. Really, do you think that Thomas Jefferson thought about that? So, I think that there's, but I think that it's important to understand that there's a controversy there about what sources that you should look at when you're going to interpret a statute. And if you've got the judge that you're arguing a case to as an advocate, remember my number one rule, win at the trial level? So if that judge that you're going to go before to argue your statutory interpretation is a strict constructivist, textualist, I love Antonin Scalia, then you should be really honing your arguments so that you're really looking at the plain language of the statute, deriving its meaning from its structure, its punctuation, its grammar, how the subsections are put together, what the title of it is. Maybe you could look at the preamble if there's some sort of intent there. But on the other hand, if you've got a trial judge that liberal activist, that works both ways, I'm sorry to say. I think that it's become just associated, or some people want to say activist judges are just those liberal people. But you know what? It goes both ways. But anyhow, so then maybe you want to, but if you have a judge that that's open to walking across the RA Gray building and looking at the state, maybe that's what you want to include in your analysis, when you're presenting that argument is, well, the purpose of the statute's right here in the staff analysis, and it was to accomplish this goal, and that's exactly what this case is about, Judge. Exactly. And so maybe you can persuade the judge with that. When you get into the canons and the rules of statutory construction, one of the things that Linda taught me is that after I asked her a question and answered Robin, so I'm going to give Catherine a little goodie bag. So, because I got to give them away and I'm almost done talking, right, baby? So,
Thank you.
but, and Robin's not here, so I guess we'll send that back. But I just had no idea. My friend Linda wrote the preface to the statute because, like I said, she's the director of statutory revision. She wrote, there's a preface to the statutes if you have the books. I'm not sure where you find it online, but I have the books. It's one thing I buy every year is the books. You open it up, there's a preface. Well, good golly, there's rules of statutory construction in the preface. The legislature is giving them to you. And as an appellate lawyer, good golly, don't I want to cite the preface to the legislature to support my interpretation of the statutes? Wouldn't that be the great argument? Instead of some Joe Blow who wrote a book, I want to cite the legislature. So So that's a good place to start in terms of what are the rules of statutory construction. What's in the statutes themselves? Linda pointed out to me, I had no idea, but there's like statutes that have rules of statutory construction. Did y'all know this? Don't tell me yes. Okay, but you know, there's like 1.01. Anybody ever read 1.01, the statutes to start chapter 1? Well, that's got 19 different definitions. So there's terms that are statutory, that are defined by the legislature as to what their meaning are. Then in section 2.04, there's laws about repealed statutes. No statute that's been repealed shall ever be revived by implication. So, you know, then you kind of get into repeal of the statute. If you had a right, and the statute that gave rise to that right is repealed, what does that do? Did you ever have the right? Maybe you did, maybe you didn't. If the effect of the repeal is to totally do away with your right, from the get-go, you never had it. But mostly repeals are looked at in terms of from this time forward. So you'll still have that right. So you have to consider what the effect of a repeal is. And there's statutes about that. Chapter 11, which is the office that creates, which is a chapter that creates the Office of Legislative Services, where my friend Linda works, gives them the job of studying and doing things to, revisers bills. Maybe you've heard of revisers bills. That's what my friend Linda does. You know, they propose amendments to the statutes that will revise them so that they'll avoid duplication, redundancy, to make them clearer. They study the statutes. Is this clear? Is there some way we can make it better? And then you might see a reviser's bill about that. That's what those are about. I always like to give the example of, because it was really kind of cool. You know that he said, she said, I just read something about it. Brian Garner, who is a legal writer, who writes with Justice Scalia, they wrote this Reading the Law book, Brian Garner. He does this little usage thing, so if you like language, you can sign up and he'll send it to you in an email. And he did one recently on that indefinite pronouns and themselves and all that stuff. But he talked about, he, she, and he called it this great. He said, oh, I used to, when I would write things right, use the royal he and exclude half the population. He, she, we say he, she now, hopefully. Some people say she, excluding that unroyal he now, right? But, there's that going on. But she did, back in the 90s, that's when the statutes were still published every other year. She did revisers bills at no cost. Didn't cost anybody, but her group of people went down and went through all of the statutes and changed them to be gender neutral. They had been written with all these he's in them for all those years, using the royal he, and excluded all of us, except for Judge Powell. So that was one of the jobs that her division did, was to go through and gender neutralize. So they went through, and every place they substituted he or she or he, or maybe resubstituted plaintiff or claimant or whatever that word was to make them gender neutral. And it had such an impact that now people just automatically do it when they draft legislation. So it really did a lot. And that was something that the reviser did, to make the statutes clearer, to make them better, to make them more fair for all of us. Don't you hate to read a law that seems to exclude you? I think that's bad. So anyhow, so you need to be aware that there's a whole bunch of rules in Chapter 11 too about what happens to statutes too. And you might want to just start in the statute books. Are you raising your hand?
Well, wait a question. Because here's the issue for me with statutory construction that I always run into. is there anything in the statute books that gives us priorities within the rules of statutory construction? Because it seems like at least half the time you can find conflicting rules of statutory construction. So what I'd really like is a nice orderly list.
Would we all? You know, that's also another point that Linda thought was really important, the old thrust and parry. And probably the real reason that, you know, Justice Scalia hates people who don't look at the language themselves, because, as you point out, the rules, the canons of construction, for everyone that says one thing, you can find one that says the exact opposite. He's written them, he's organized them in this book. It's really interesting. There's like, he's organized them all in terms of ones that are canons of, you know, the semantic canons, ordinary meanings, contextual canons, expected meaning canons, government structuring canons, private right canons. You know, so he's, I mean, gone through stabilizing canons. He's got them all right here. So if you really, I mean, you know, I'm not saying, but geez, you know, it's kind of interesting. And he is Supreme Court Justice. I don't know. But so Linda thought it would be interesting if we all talked about exactly that question. So a statute cannot go beyond its text. What's the opposite of that? Something that's the opposite of that. To affect its purpose. Oh, that's not textualism, is it? To affect its purpose. A statute may be implemented beyond its text. See why Justice Scalia hates that? Because you're looking at purpose then. Unless that purpose is written into the statute, and not many statutes actually say, and the purpose of the statute is, sometimes they do. I mean, I've seen statutes that actually say, the purpose of the statute is to overrule the specific decision that the first DCA made, you know, or the Supreme Court made. You know, sometimes it can be so specific as that. But, so, you can say, statute can't go beyond the text, but you know, in those hard cases, and that's where I said, the canons are never going to come out with a result in a case that's really hard, where the facts are really hard. Because somebody's going to argue, well, you know, the purpose of the statute is this, and so you're going to have to go beyond the text, because the text just doesn't cover this factual situation. Okay, here's the one that y'all know. Statutes and derogation of the common law will not be extended by construction, strict construction to laws that are contrary to the common law, okay? Well, what about remedial legislation? Remedial legislation is generally not common law. Well, that's supposed to be liberally construed. So what's the purpose of your statute? Is it something that is remedial legislation? Then you're going to be arguing that that's a liberal construction. Statutes should be construed in pure materia. I'm not good at that, all that Latin stuff. So, but I can say pure materia, so together. But then the opposite of that, a statute is not in pure materia if its scope and aim are distinct, or where a legislative design to depart from the general purpose or policy of previous enactments may be apparent. So maybe sometimes you really just do need to focus on a little bit of what's in the statute to be able to come up with your purpose. So, and then there's the old criminal ones. Statute that imposes a new penalty or forfeiture, so regulation, criminal stuff. They're not going to have a retroactive effect. You know, that's, remember those ex post facto laws in criminal, so we're not going to give something that creates a new penalty ex post facto. Well, once again, our friend remedial laws, because they're remedial, we're going to give those, you know, retrospective application. So it's exactly, you would like the list, but the list, which is just Justice Scalia's point, is the list has some things in it that would support what you're saying, but that good advocate is going to find something that's going to be contrary to what you want. So that'll be your job, to find that contrary when it's, like I said, you want to convince that trial judge of the correctness of your point. And so it'll be your job to dig that out. But there's a whole list, and that really is his point, is that any of the canons, and that's why he doesn't like them, are going to be capable of being countered by another canon. So your job as an advocate is to persuade which canon controls. So, like I said, I'm not good at Latin because English, I'm not very good at speaking, but expressio unis, the expression of one thing excludes everything else. Remember with those little laundry lists in there? I don't know, nocitor associus, I don't know. The meaning of doubtful words may be determined by the reference of associated words. So, the last antecedent, that's the last amendment that was passed in the session that's going to control. Every word is supposed to be given effect. Different words mean different things. If you use the same word in one place, if you use a word in one place, it means the same thing someplace else. So there's lots of different rules of construction. Your job as an advocate is to find the ones, of course, that help your client. And Nancy just raised her hand for 5 minutes, and I have a very low concentration level. So, of course, that would she thought she was being discreet, and that just throws me off. So. But I think since it's 5 minutes, I'm gonna take your question, and then maybe y'all have questions.
Is there any, what is the mechanism by which, after a court has ruled on something that has overturned a statute or defined whatever was ambiguous, what is the mechanism by the legislature going back to amend or to correct that, or does it even get corrected and it just stays in the record that it was overruled by the judiciary and then it can just hang out there? Or
isn't that one of those rules of statutory construction?
Right.
That if a court has interpreted a statute in a certain way, and they sure as heck and they don't like that, they sure as heck better do something about it at the very next legislative session, or we're going to presume that the legislature was aware of that construction and we're going to construe it that way. That's why with Emma Murray, they quickly changed reasonable, because they didn't want that to continue anymore, and they did it in the very next session. So that's what they're going to do, is they're going to pass a bill that'll change that interpretation if they don't like it. If they like it, let it be.
But what if it's one of these political things? I'm thinking specifically about 741.212, which is the definition of marriage in Florida. And the reason that this is relevant to me is because I'm a real estate attorney. And so I spend a lot of my time in my practice where I am now putting together deeds for same-sex couples who are getting married and are purchasing property together. But under Florida law, joint tenants with rights of survivorship is their only avenue. They can't have tenancy by the entireties. But the Florida statute says they're not legally joined in marriage. They're not allowed any of the privileges of being considered a married couple, yet obviously we have rulings from the circuit courts that are saying differently. We're waiting obviously on the Supreme Court, but I don't see the legislature actually wanting to take up this issue in any way, shape, or form to correct what is clearly going to be an issue once the Florida Supreme Court probably is going to have to get involved, once the federal Supreme Court is going to have to deal with it. So,
oh well, and I guess
what do we do in the meantime?
And that's kind of one of the problems with statutes. Because remember, I started off, what are they? They're rules of social conduct. Well, they can be very controversial, rules of social conduct. What you think is okay, not what you think is okay. And And a lot of those things in this culture that we live in today become very politicized, haven't they? And so we're going to take a controversial topic, we're going to politicize it, and then we're going to hope the legislature gives us some guidance so that we can control our social conduct and can know, will this house be ours? Will this house be mine when my partner dies, or won't it?
And more importantly, am I going to be sued for malpractice if it doesn't go right? That's really my issue.
Right, so, and this would not be the first time or the first topic in which the legislature has dodged the issue. Sometimes that happens, that there's a controversy out there brewing, and they know it's brewing, and yet nothing has happened. Is that because they can't make the sausage? Maybe. Maybe it's just as a body, they're just unable to make that sausage. They try, they can't. Maybe they don't want to even go to sausage making.
Right.
And the first thing that has to happen is somebody's got to sponsor a bill.
Yeah.
Right? It doesn't just,
Yeah, but somebody's got to sponsor a bill. So, and who wants to be that sponsor? Sometimes you don't want to be the person who sponsors that bill. So sometimes then things are left to the courts to decide. And then when the courts decide it, based upon those rules of statutory construction, in a way that the legislature doesn't like or political people don't like, they'll be labeled activists. One way or they'll be labeled activists by either side, right? And the courts will get a bad name because the legislature didn't do what they were supposed to do, and or couldn't do what they were supposed to do, as the case may be.